Good morning. Actually, what had happened? One uh, Tanse Lodi was having two sons. One Mr. Giridhari Lodi and another one Nanne Lodi. The father and two sons partitioned their property by sharing the property which were available in the villages. Then what after the Tanse Lodi, who separated from his father after partition, seems to have, on death of his father, uh, Tanse Lodi, this Nanne Lodi seems to have sold certain property, claiming that being a son of Tanse Lodi, he is having some share in the property. Therefore, the other son, who was residing with his father jointly after partition, filed a suit for declaration to declare that the left out property was belonging to him. So that was decided in favor of the Giridhari Lodi, stating that since this other son, after partition, obtaining his share in the compulsory property, left the company of father, he is not entitled to inherit the property of the father. But this seems to be a very a different aspect of how to deal with Section 6 of the Hindu Succession Act, which deals with the compulsory property. Let us see the judgment, how far will hold good by Supreme Court. Because this area, in this judgment, I don't think any Supreme Court judgment was discussed. It was only discussed some Karnataka judgments. One SC judgment was also seems to have been discussed. I do not know how far this judgment is going to be declared as a law under 142 Article Constitution of India. I think you understand this is a case of AR 2022, Madhya Pradesh 125, Giridhari Lodi through legal error versus Chakki and other. AR 2022, Madhya Pradesh 125, Giridhari Lodi versus Chakki. Concept was that the compulsory property, joint family property, ancestral property between father and two sons were partitioned and one son left. The other son was residing with his father. Therefore, after demise of the father, the left out son, whether having property or not, that has been decided here. However, another aspect was also decided in this case, that was a limitation, because the suit for declaration of sale null and void was filed after 3 years. However, the defendant slept over that issue by raising any objection even during appeal. Therefore, the Madhya Pradesh High Court also not considered that aspect of whether law of limitation is question of law, which could be raised even without raising in the written statement or not. It's also to be decided by the apex court later on. Best wishes.